Hello everyone, welcome back. In the last two classes, we discussed the first two parts of competency of parties. And before that, if you remember, currently we are discussing all the conditions that are required for an agreement to become a contract. Correct? We started with this. And the first condition that we were currently discussing was competency of parties. In competency of parties, I told you that three kinds of parties are not competent to enter into an agreement. One is a minor, second is a person of unsound mind, and third is a person who is prohibited by law. Alright, and we have covered the first two in the last two lectures. Today we are going to look at this element, prohibited by law. Alright, for minor we had seen that any agreement with a minor is what? Any agreement with a minor will be void ab initio, correct? Which means it is not enforceable from the beginning. And the only exception is when a minor enters into an agreement for necessities, which means that the exception would be necessities of life for the minor. Alright? And unsound mind, I told you the only condition is that the person whose unsoundness of mind is in question, that person is not in a mental state to understand the terms of the agreement. Alright? So basically two things, that person neither understands what is mentioned in the agreement, nor is he able to comprehend or understand the consequences of the agreement, which simply means as to what will happen if I enter into this agreement. Usually whenever you enter into an agreement with somebody, this is a question that is always there in your mind, that okay, I'm signing this agreement, what is the effect of this agreement? Okay, but anybody who is of unsound mind, that person is not able to understand firstly what is written in the agreement, and secondly what is the effect of this agreement. Okay, and therefore the law says that whenever there is an agreement with a person who is of unsound mind, that agreement is voidable. And we had looked at the difference between void, ab initio, void and voidable in the last lecture. And just to summarize, voidable simply means an agreement which is capable of being enforced at the discretion of the relevant party. Alright? And when we are talking about unsoundness of mind, who does the law give this right to? Who has the right to enforce the agreement or cancel the agreement? That is simply what voidable means. Whenever you look at the term voidable, you just have to remember one thing. There's an option to enforce or cancel the agreement. Okay? And who can do so? That is something which the law tells you for specific scenario. So these are the 2 pointers that you need to remember whenever you're talking about a voidable agreement. It means that there is a party who has the right or the authority to either enforce the agreement, which means to proceed with the agreement, or revoke or cancel the agreement. Even if the agreement is signed, this party has the right to revoke. Whenever you see such a scenario, you see that the agreement is voidable. Okay, so in unsoundness of mind, I told you that this authority is given to the person who is of unsound mind. So anybody who is of unsound mind at the time of formation of the agreement has the right to either proceed with the agreement later or revoke or cancel the agreement. So this right has been given to the person with unsound mind when at the time of formation of the agreement. All right, let's look at the last portion pertaining to competency of parties. Law says a party to an agreement should not be prohibited by law from entering into the agreement. So it simply means that the law should not prohibit any particular person from entering into an agreement. And can you think of any scenarios where this may happen, where the law itself says that, look, a person A or a person B cannot enter into this agreement? Okay, if you're unable to think, let me give you a few examples which can help you think and understand this concept properly. Now, there could be a scenario where a person is above 18, okay? So where a person is not a minor, where a person is of sound mind, okay? So both the conditions are met. We saw that competency of parties, this condition says that a party should not be a minor. It also says that a party should not be of unsound mind. So just imagine that we have a scenario where both the parties to the agreement are not minors and both the parties are of sound mind. Okay? So we have both these conditions fulfilled. But still, the law may say that even if you satisfy these two elements, you will not be able to, or you do not have the authority to enter into an agreement. The law may say so. Okay? And let's look at a few real life type examples. Okay? Let's understand the situation of Vijay Mallya. What happened in the case of Vijay Mallya? Very briefly, I won't go into the details. Vijay Mallya took huge loans, okay, from Indian banks. And he did not repay those loans. So Vijay Mallya took loans, okay, and then he did not repay. What happened as a result of that? The result was that, so what happens in a real life scenario where somebody takes a loan and does not repay the loan? Okay, what do you think would happen in such a scenario? The simple answer is the lender, the party who has given a loan, will seize some properties of the borrower, correct? So if I have a house and I take a loan, okay, and I am not able to repay the loan, and house is my only property, the lender, the bank, can take control of my house. Okay, as in there are ways to do that. We will not go into the specifics of that. For example, some of you may ask, can the bank come to my home directly and take the key from me, or will they have to go to the court first? Don't go into the specifics of that. That is not our objective. All I'm trying to tell you is that there's a party who has taken a loan and he has failed to repay. Okay, the recourse available to the lender is to take control of the property. Just imagine that scenario. Okay, what happened in the Vijay Mallya case also? He fled to some other country. His properties are in India. The Indian government took control of certain properties. Okay, now in this scenario, forget Vijay Mallya, take my example. I have taken a loan, I did not repay, okay, because I don't have the capacity to repay. Let's say I'm unemployed, I don't have money, so I'm not in a position to repay my loan or EMIs. Understood? Now, if that happens, as I said, the bank will take control of my property. Okay, but after a few days, let's say after a few days, I enter into an agreement with you. where I tell you that let's do an agreement where I sell my house to you for rupees 1 crore and you agree to buy my house for rupees 1 crore. Both of us are majors, which means that both of us are not minors. We are above 18 and both of us are of sound mind. What is the what is the agreement here for? The agreement is to sell my house, okay, for rupees 1 crore. Question: is this agreement valid? The answer would be no. And why not? Because I am prohibited by law from agreeing to dispose of my house. Did you understand? Did you follow this? In simple parlance or in simple language, you might have heard a term which is known as insolvent. Okay, if a person does not have the capacity to repay the debt that he has taken or repay the money that he has taken as loan, then that person becomes insolvent. Law says insolvents should not be allowed to dispose of their property. And why would the law say so? The logic is quite simple. First of all, this insolvent person has not repaid the loan, and if you ask him, if you give him the authority to dispose of his assets, that is what he will do, because he will know that the bank will come after the property. So let's dispose of or sell the property before the bank or the court comes. So therefore the law says that if somebody is an insolvent person, which means that that person has not repaid the loan and does not have the capacity to do so, then let's stop that person from dealing with his property. Correct? Which is what happened in my case. I am an insolvent. Firstly, I took a loan. Later, I was not able to repay the loan, so I became insolvent. I have a house. As per this principle, I'm not allowed to sell my house, correct? Because I'm not allowed to touch this property. Even if the property is mine, I'm not allowed to touch it as an insolvent. So the agreement that you and I entered into to sell my house at rupees 1 crore, that agreement is not valid because I am not a competent party. Okay, so first category that you can remember is that of an insolvent person. Okay, whenever you read about persons who are prohibited by law from entering into an agreement. So generally, there are exceptions everywhere, but the general rule is that insolvents are usually prohibited from entering into agreements regarding disposing of or selling their assets. All right. Let's look at another example. I'm sure all of you know Ajmal Kasab, correct? Who was Ajmal Kasab? We know that a decade ago, almost a decade and a half ago, there was a terrorist attack in Bombay at a hotel, correct? Taj Hotel. And this person was the mastermind, or you could say the main perpetrator of that attack. Now let's say Ajmal Kasab is sitting in jail, okay? And he wants to do some business in India. He has a lot of money. Assume that he has a lot of money. And he wants to do some business in India while he is in jail. And you would have seen a lot of politicians, they are in jail, but still they are running huge businesses. Just imagine that situation. Don't get confused. Okay? So Ajmal Kasab wants to enter into an agreement with Gautam Adani. Okay? He wants to enter into an agreement with Adani, where the arrangement would be such that Kasab and Adani would work together, okay, let's say for a solar power plant. That is the business which Kasab wants to do with Adani, okay. And therefore, both of them enter into an agreement for this business venture. Question: is this agreement valid? Now, the first part that we are looking at currently is competency. Whenever you are presented with a situation where you have to decide whether the agreement is valid or not, okay? When I say whether the agreement is valid or not, right now we have to determine whether this agreement is capable of becoming a contract or not, correct? I hope you remember from where we started this discussion. We said that agreement plus certain conditions is equal to contract, and we have to determine whether these conditions are being fulfilled or not to decide whether an agreement is capable of becoming a contract or not. So the first condition is competency, which we are discussing. Now, in Ajmal Kasab and Adani case, both Kasab and Adani are above 18. Both of them are of sound mind. So both the conditions are met. The only thing that we need to check now is whether the law prohibits any of these parties, Kasab or Adani, from entering into this agreement. Okay, does law prohibit either Kasab or Adani from entering into this agreement? And always remember, all the things that we talked about so far for competency, it's not necessary that both the parties need to be incompetent. For example, when we were talking about the minor situation, we know that in an agreement there are two parties, offerer and offeree. Whenever you are dealing with a competency related situation or problem, all you need to check is whether any of the parties is incompetent. Okay, the law does not say that both the parties should be incompetent or should be competent. So even if one of the parties is a minor, that party becomes incompetent and therefore there is no contract. All right. So in this scenario, does law prohibit either Kasab or Adani from entering into the agreement? What do you think? The logical answer should be yes. The law should not allow Kasab from entering into this agreement. Why? Because he is an enemy alien. What is an enemy alien? First thing, alien is, who is an alien? If you've read the constitutional law, you would have come across this term in enemy alien, friendly alien, all of that. So alien is basically a citizen of some other country. Okay. In this context, let's say Kasab is a Pakistani citizen, then Kasab is an alien to us. For us Indians, Kasab is an alien. All right. The second thing is enemy. Why we use the term enemy here is because, let's say, India is at war with some country. Imagine India is at war with Pakistan. Then Pakistan is an enemy country currently till the time the war is ongoing. And anybody who is a Pakistani citizen becomes an enemy alien for us. Okay. And usually the law will say enemy aliens cannot enter into agreements with Indian citizens. This is usually the rule. Again, as I said, there could be exceptions, but just for your general understanding, imagine this, that and just assume this, that if somebody is an enemy alien, the law says the enemy alien should not be allowed to enter into an agreement with an Indian citizen. Gautam Adani is an Indian citizen. Kasab is an enemy alien. So the law is explicitly prohibiting Kasab from entering into this agreement with Adani. So we have our answer. Does law prohibit either Kasab or Adani? The answer is yes. Okay. So I hope you have understood this entire competency of parties element clearly, because this is the groundwork or the platform for us to discuss the next conditions, which are more complicated. Competency is quite subjective. It's very easy to determine, and therefore once you understand this properly, then you will be in a position to take the discussion at a relatively higher level. Okay, so what have we learned so far? For a person to be competent to contract or to enter into an agreement, what do we need? He must be a major, correct? Or in other words, he must not be a minor. He must be of sound mind. And lastly, he must not be prohibited by law. And if any of these is missing, then there is no valid contract. If any of these is missing, it means no valid contract. All right, tomorrow we are going to look at the next condition, which is free consent. Okay, very interesting area and extremely difficult also, because as I said, to check competency is quite easy. Okay, because this is an objective element. Example, if you want to see whether somebody is a minor or not, all you need to see or all you need to check is the official identification document, correct? I know that soundness or unsoundness of mind may become slightly subjective, but still competency is something that is easier to crack as compared to free consent, and therefore free consent is an area that CLAT loves quite a lot. Okay, so be prepared for the next few discussions on free consent, because free consent is a very vast topic, and I will try to ensure that I'm able to apprise you of all the relevant or possible scenarios where CLAT may question you, and at the same time I will ensure that the lectures do not become so lengthy that the syllabus, as in that we'll have to spend so many days only on law of contracts. That is also the objective. Okay, because we have to finish the entire syllabus by July September of 2026. All right,